Good morning, members, and thank you. Let me just get that out. Sure. One moment. Okay. Thank you, members, and I call this 23rd Special Committee on Federal Assistance and Disaster-Related Funding uh, meeting to order pursuant to the Open Government Act, 1 CMC subsection 9901. It was sent out last week. I believe everybody was given a copy of that agenda. Is there anyone in the members here are present that didn't get a copy? Everyone got one? Thank you. With that, I believe we have a quorum to proceed. Everyone is present. I would ask the vice chair to motion for the adoption of today's agenda.
Thank you, Chairman. I move for the adoption of agenda.
Thank you, Rep. Probst. There is a motion to adopt today's agenda and has been seconded. All those in favor say aye. All those opposed say nay. The ayes have it. Moving along, public comment. Is there anyone in the public that would like to make a comment? Being there's none, I move to item 4. Under federal assistance and disaster-related funding, subsection A, the review of legal authority to conduct investigative research and investigation. Now recognize our legal counsel. John, please.
Thank you, Chair. This is not a complete list of all of the laws that might be relevant to the work that you're going to do, but I tried to identify the ones that would be the most relevant immediately so that you could have a reference sheet and that we could go through it and just highlight the authority that you will act under so that when the committee makes decisions, it does so as closely connected to whatever authority that it has. We do this because the last time this happened, there was litigation in court, and it required us to justify the authority of the legislature in certain areas. And the closer that we stick to these constitutional provisions and statutes and rules, the more you're protected. So the CNMI Constitution, as to handling an investigative committee, sets out in Article 2, Section 14, under subsection B, where the House of each house of the legislature chooses its presiding officers, but the underlying sentence there is the one that's relevant to investigations, and that says that each house may compel the attendance and testimony of witnesses and the production of books and papers before the House or its committees. So it expressly gives both the Senate and the House essentially subpoena authority that you can issue and focus upon a person. You can require a person to attend, and as pointed out earlier, that person doesn't have to be a member of the government. It's just someone that's reachable within CNMI. And you can receive production of things such as books and papers, so documents and records and things like that. So that's really the engine of what gets an investigation initiated. You can bring people here and you can bring things. The code sets out some of these processes in more specifics. And under Title I, Section 1301, it identifies how legislative investigations shall be handled with regard to subpoenas. Those subpoenas can be issued by the Speaker of the House or other presiding officer of either house of the legislature. And a presiding officer would include the chairman of committees. And so the chair of this committee, independent of the speaker, can sign and issue subpoenas. And that's what was being referenced earlier, that the chair would be seeking your consent for that. And again, it would be requiring the attendance of witnesses or subpoena ducis tecum, which is just the Latin phrase for a subpoena for things. And it can be in any matter pending before either house or a committee. And this is why Joe was referencing the need for a subject. Committees don't exist in a vacuum to just investigate. Your ability to reach out for people and things is not unlimited. It is to be focused upon a matter pending before either house or a committee. So we need something pending before the committee. And that is why it was suggested that the committee be asked through a communication, perhaps from the speaker, to focus on particular legislation, to focus on particular previous information that was obtained through investigation. So it would be helpful to have referred to this committee by communication all of the information that the previous JGO in the 22nd collected and place it before this committee, because it was important, but some of it was unfinished. And then, as Joe suggested, it would be helpful to have relevant bills referred to and pending before this committee. An example is the bill dealing with how budgeting should occur for certain federal funding, such as ARPA. There are several other bills that could be related to that could also be referred to this committee. It just needs some subjects to focus upon that you're investigating. And we have a general idea through the name of this committee, but we need some specific legislation to focus on. Any questions about that? Subsection B says every investigating committee, when authorized by either house or both house, may issue by a majority vote of all of its members subpoenas. So the mechanism for the chair of this committee to actually sign and issue a subpoena is to make the request before the committee and for the committee to vote, and a majority vote will authorize that chair to sign and issue that subpoena. And then under subsection C, the sergeant at arms goes out and serves it, and we carry it out. The subpoena doesn't just name a person or some documents. There are a number of things that have to be in the subpoena for it to be legally sufficient. And probably for the purpose of what we're talking about today, the most important is that it shall set forth in general terms the matter or question with reference to which the testimony or other evidence is to be taken. You need a subject. You need a specific area that we are seeking to investigate. Again, that's why you have the previous JGO information. That's why you have specific bills, so that you can focus whatever that witness information has upon the need that you have. That's the language for that. Council can work with you on that we would need for specific subpoenas, but you would first need bills here for us to focus on. And then section 1302 indicates how these subpoenas are carried out. If you are requiring the attendance of an individual, they get at least 5 days prior to the hearing of notice, unless you shorten that period of time. It's very typical for a witness, once receiving the subpoena, if they had conflicts, to contact the committee, and then either they will appear on that date, or if they are unable to, the committee can make decisions through the chair on whether or not any accommodations will be reached on that. Again, under subsection B, when they're served with that subpoena to appear, they are entitled to receive a general statement of the subject matter of the committee's investigation or inquiry. And again, they can also have an attorney if they wish. Typically, we're notified of those things after they receive the subpoenas. If they appear with counsel, they have a right to do that. That a counsel may appear with them before the committee and may advise the witness as to their rights. The committee and the chair can certainly limit how counsel communicates so that it doesn't interfere with the questioning and doesn't obstruct or interfere with the ordinary conduct of the hearing. And the witness can also, through themselves or counsel, submit their own questions if they have certain ones that they want asked. 1304 covers the testimony. There will be a record of this. Typically, it's recorded. That's why it's important for you to get a record of the previous JGO hearing from the 22nd. It includes, I assume, a recording of all the testimony from the witnesses that can be watched, as well as the journal from those hearings. When witnesses testify, you can place them under oath, requiring them to testify under oath. Subsection C indicates that the individual who administers that oath is the presiding officer, which is presumably the chair. And that presiding officer oversees the testimony and directs it, and directs to who will direct the question. If the witness does not answer, can direct the witness to answer and to provide certain things. If the witness is disobedient, does not comply with the subpoena, then that is contempt. That is something that is referred at a later date through a later process to the Attorney General for prosecution. A referral of that type was made by the 22nd in the JGO hearings for the purpose of contempt against the former governor. That's what resulted in the litigation that happened and is currently pending in the Supreme Court as to the immunity allowed the legislature from litigation. That opinion hasn't yet come out. The trial court ruled in favor of the legislature, but the Supreme Court hasn't ruled yet. But that referral to the Attorney General was for the previous governor's non-appearance on the subpoena. That contempt was initially filed by the Attorney General's office. It was subsequently dismissed because of a conflict of interest involving one of the lawyers representing the Attorney General. They now have a special prosecutor, and those charges could be reinstated if the special prosecutor so chooses. But if you had a non-compliant witness again, that same process could be followed. The rest of this is just how people behave during that. Section 1305 deals with interested persons. And essentially, if someone has their name mentioned during a hearing and they feel like they need to come and correct the record or talk about it, then they're allowed to do so, or they can file a written statement. And you can, of course, allow other people. As we'll find out in a minute, subpoena isn't the only method for people appearing here to testify. A subpoena is simply a method by which you require someone to testify. Section 1306 deals with the contempt that we were discussing. If the person just does not appear after receiving a subpoena, that is essentially a criminal violation of contempt. If they appear but refuse to answer a relevant question or to furnish a thing, that you've requested, that can be contempt of court. If they appear and answer but are very disrespectful or try to disrupt the proceedings, that too can be contempt. If the committee decides that contempt is appropriate, then it would take a majority vote to report to the House. And then the Speaker would be the one to certify a statement of contempt and refer it to the Attorney General for prosecution. This simply describes, 1307 simply describes what that criminal offense is in terms of punishment. That's essentially a misdemeanor, up to 1 year of confinement and up to $1,000 fine or both. This discusses the limits of what sorts of defenses and privileges a witness can say about why they don't want to testify. And it does incorporate the rules of evidence, which, there are certain pieces of privileged information. For example, conversations one has with one's own lawyer is privileged. That means you can't require someone to testify about the advice that they got from a lawyer. Section 1308 is the provision that was referred to earlier, and it's the most commonly used section by an investigative committee to gather information. And it simply indicates that government officers and employees shall cooperate with an investigating committee. So if you make just a simple written request, perhaps through letter, and identify a person or some things, this provision informs government officers and employees that they shall cooperate with the committee and provide that information or come and testify. Now, not everyone does. So that's why a subpoena exists, to follow up with that. 1309 simply indicates that there are any other lawful method of obtaining information. Those are the highlights of the statutes that are relevant to this. The House rules duplicate a lot of this and talk about the duty of committees. So Section 4 kind of digs down a little deeper into why you need bills. The duty of a committee is to make a diligent and careful inquiry and investigation into all of the facts and circumstances connected with bills, resolutions, or other matters referred to it. So we want to connect your work to actual ideas for bills, actual bills themselves or resolutions, or when it says other matters, like all of the information that was collected by the JGO on the 22nd. Rule 12, Section 1 goes into the specifics on subpoenas and indicates very clearly that any committee chairman or authorized person may issue subpoenas by majority vote. Now, technically, if someone refuses to appear and ignores the subpoena, the committee could simply ask the sergeant at arms to arrest the person and bring them here. That's a very weighty decision that's been considered in the past, but typically a referral for contempt is also considered. This is a little bit more of a description for what contempt is. It's essentially contempt in court and in the legislative processes where someone shows disrespect by their behavior. So it could include things like yelling and disrupting or throwing things, in general, not behaving very well in front of the committee. Okay, that's a quick review of the Constitution, the statutes, and the rules that are relevant to investigative committees. Joe was here for all of the JGO hearing. I started in like October, so I got here toward the tail end of it. So I did see some of it, and we're fortunate to have had some experience with that, and Joe having substantially more. Questions?
So in the event that there is someone or a person of interest, and this individual is obviously off island, right? Are we even affording, or can we afford anyone to appear in another form besides being present?
They would have to be served
Okay,
in some form
okay.
to require them to appear here.
So they would physically have to be here. We can't afford any other method of them to appear.
Well, as I mentioned, a subpoena is the last resort. If someone is cooperative
Mhm.
and wants to appear, you have many choices. They can appear in person, they can appear by phone, they could appear by video. But that's up to the committee.
So is this something that we could, I mean, just to save time, shall we, I guess, include this language somehow, or we
Well,
don't need to?
I think the language is already available. We talked about that catch-all language. I just didn't stop on it for very long, but it says if you look at section 1309, nothing contained in this chapter could be construed to limit or prohibit the acquisition of evidence or information by an investigating committee by any lawful means not provided in this chapter. So if it's consistent with CNMI law and the rules that you have, then you can do it. And I don't know of anything that prohibits you receiving information that way. So I would consider all of those choices lawful.
Thank you, John. Just one question, John. So if, for example, a witness calls my office, wanted to speak to me in person, does the committee need to be involved, or a one-on-one is permittable?
That's a really good question, and I would suggest that's the sort of organizational thing that the committee should decide. You can decide upon some formal rules for that process. The committee could defer to the chair in making those decisions. Those are the kinds of decisions that the chair will have to come up with a process that the committee is happy with.
Thank you, John. I believe I handed over to our other council to set the ground rules. Is that already done, council? No, you can answer first.
I sent a copy of the conference committee rules, Chairman. I spoke with the former chairwoman of the JGO, Selena Babauta, and she confirmed that there were actually no written ground rules with respect to the committee as far as kind of like housekeeping, administrative matters, how we would deal with the information as it comes in, talking to the media, speaking to the media, stuff like that. There were no ground rules that were written. But we have conference committee rules that we could use sort of as a guideline that we can discuss.
Okay. Well, I want that rule set because when we request for information, for example, through, let's say, the Bank of Saipan, there's going to be private information that will be shared. So we want the ground rules for that, as how to receive information and how to disseminate information. And then either the chair or the vice chair would have the authority to issue those before it's disclosed, because I believe this portion of the investigation now is a lot of reporting that it should be submitted to the Bank of Saipan. So we need that ground rule set up, because there'll be a lot more private information that will be shared with us. Thank you, Council. Rep. Flores.
Thank you, Chairman. So again, right, and that was going to be my follow-up question as far as rules and housekeeping. I think since you mentioned there was nothing in there about more defined of what our roles were, I think also, Chairman, if there could be a section in that council that obviously were privy to very confidential information, and this body is now acting as investigators to kind of provide our evidence and prove that there has been some way, shape, or form misconduct or misuse of federal funds, right? I think that we should also put in a clause there that whatever is shared within this committee, that in no way, shape, or form it should be shared or discussed in any social media platform, unless it's period. That's it. I don't think, and I believe wholeheartedly that we will be privy to information, and that any and all discussions, whether in session or out of session, should not be discussed at all. And if that could be considered as a rule, I'd really appreciate it. Thank you.
Thank you, Rep. Flores. Any other questions, comments, concern with regards to the rules? Vice Chair.
Chair, if I may, I know that part of the agenda on item B was rules and perimeters of conducting, and I heard you just question the legal counsel, and we don't have any drafted ground rules yet at the moment. So
Yes.
how do you
So,
suppose we move forward with this?
We'll table item B until the rules for receiving information is done. I believe the council sent me a draft form. We just need to finalize it, no? And then we'll go from there. So if there's no objection, I would like to table under agenda 4B on the ground rules. We'll set that for a later date. So if there's no objection, I'd like to table that.
Mr.
Rep,
Chairman,
yes.
thank you. Maybe I think if we're gonna work on the ground rules, I think it should be general. It should be a generalized ground rules, because as we move on in this process, the rules may change, and we're gonna have to go back to amend the rules. I think it should be a generalized rule. The one rule for sure that I would recommend for this committee, that any media coverage shall go directly to the chairperson of this committee, and no other member from this committee shall be talking to the media, and we'll have everything funneled through you as chairman or your designee to talk to the media, just so that information is in line from coming out from this committee. If there's no objection from any of the members, but I
Is there
think
an objection?
but the rules itself should be generalized. Honestly, I've been in special committees in a couple of them, and the rules change in the process. And I can see that the chair wants some sort of rules, but I think it should be generalized, because it will change down the road when you're going to have certain witnesses that may, I don't know, they may ask for a translator, for example. Right now, we have to allow them to get a translator, and then we have to also get a translator. Whether they use our translator or not, that's going to be up to them. It's their right. So the rules may change down the road in this process. So I think we should be pretty flexible in our rules. And with all due respect to the members, if there's no objection, I think whatever the rule that the chair has decided on a general basis, we can live with those rules and consider it accepted by this committee. And should any additional changes to the rules, we will ask the chair to make the additional rules, and we can vote on it in the future. But I think tabling the rules and parameters of this thing is it's not necessary. I think we'll respect you as the chairman of the committee. The only ask is, I say, that when it comes to media, that the chair or the designee should be the only individual that can speak to the media regarding the committee's investigation. Thank you, Mr. Chairman.
Thank you, Rep. Atal. Any other questions? All right.
I actually have a comment, Chair, and I can't, I have to support Rep. Atal on this. A lot of the things, even watching it from the outside in the 22nd legislature, there was a lot of information that was passed out that should have been, confidential, but somehow it leaked, and then therefore causing a misconception or people to draw their own conclusions on an investigation that was still ongoing. So I also support Rep. Atal that the rule should be general. However, there should be a section in regard to media and how this committee will address the media, and that it should be designated to either the chairman or his designee. I
Thank
yield.
you, Rep. Flores. Rep. Camacho.
With that said, then why don't we just take the oath also? We'll take the oath and give ourselves some immunity. Thank you.
I think we already took the oath. So, Rep. Camacho, Joel.
Thank you, Mr. Chairman. Quick question. If we are going to move forward in this committee, just curious as to how are we going to proceed if there's an ongoing investigation that is being conducted by the Attorney General's office or any other office out there that's doing their investigation, maybe even OPA. And if we were to subpoena a witness or anybody that was involved in the last administration to move forward in this committee, and they inform the committee that they're actually, involved in a current ongoing investigation, how do we proceed with that? Maybe it's for the council.
Yeah, okay. Council, any?
The simultaneous use of a legislative investigative committee and a separate criminal investigation, whether it's through federal agencies or CNMI agencies, can sometimes create a conflict. And that's just a decision that the committee has to make on how it proceeds on that. The witness always has the option of invoking their privilege against self-incrimination under both the U.S. and the CNMI Constitution. And sometimes witnesses will appear and say, I choose not to. They have to appear. They don't have a privilege not to appear. What they have is a privilege not to answer questions if they think that they will tend to incriminate them, and they can announce that privilege at the time. It doesn't mean that they can announce it to every single question. If you're asking them their name and their job and what their background is, none of those things tend to incriminate someone typically. But the point at which a question they believe intersects with a criminal investigation that they think that they might be a target of, then they can invoke that privilege. As to whether or not your collection of this information will interfere with other investigations, that's a big question. And since we're not privy to what those investigations are, and we're not part of those investigations, I don't know that we can give you any definitive advice about that. That's just something that you have to take into account yourself.
Thank you, John. Vice.
Thank you, Chairman. Thank you, colleagues. Because we've heard this come up before several times. Well, what if there's a pending investigation by the AG or the FBI? That's really not our concern. We don't bow to the FBI or the Attorney General. We have separation of powers for a reason. And if they happen to be investigating it, fantastic. If they're not, then that's their call. But we don't call up the Attorney General and say, is it okay? Can we do this subpoena? No. That's not how we work. Okay? With all due respect. This committee, the special committee, was called together for a reason. And it is not just focused on ARPA, which has been misleading to some in the public and the community to address them. It is one part of this, but this is the federal assistance, and this is a committee, special committee on federal assistance and disaster-related funding. So we may go into things that are under investigation. And as our legal counsel has stated, that if somebody comes in and they're being questioned, they simply have to make that statement that I cannot answer that due to a conflict or whatever. But it is totally our call. and we use this. I also want to, with respect to something that's sounding like a gag order, that only the chairman can speak. This is important when it comes to sensitive information. This is important when we did this before. This is not a few of us that have done this before. It's not our first rodeo. We've been through this before. And there's concern about leaks of specific information. But it is the chairwoman at the time, Selena Roberto Babalta, who would decide whether to disseminate this to the public or not. And generally she would, because she felt that the public had a right to know, as long as it was not sensitive information that should not be released. You wouldn't want to release somebody's social security number or something like that subsequent to that. So those are the rules that we're dealing with. As a vice chairman and part of this committee, I don't think the chairman or myself would have an issue if somebody was asking your opinion on something. I think the concern is if you were speaking on behalf of the committee. And that's why, as Chairman BJ Atao had said earlier, that, we should refer to the chairman on speaking on these press releases and other things. But if somebody were to ask you a question on how do you feel about something, I don't think the chairman would be upset about that. The only thing is we have to be careful on when we do receive information and ensure that it is not being released if it is, like I said, specific to the investigation. And I do want to say that with regard to other things that we are going to be looking into, it could be possible that it could be a ARPA-funded project, a contract, a sole source contract. I'm not saying that that's going to happen, but say somebody got $1 million sole source contract for a service or a product that was only worth a tithing of that, 1/10 of that. Is that fair? Things like that may be looked into, and that would be part of our investigation into such matters. Thank you, Chairman and colleagues. I yield.
Thank you, Vice. Is there any more? Rep, hold on.
I think that everybody could, thank you, Mr. Speaker, Chair. I think we could all agree that as long as we do not impinge on their First Amendment right, their with U.S. Constitution or the Sinai Constitution, we'll be okay. We'll be fine. We definitely cannot force them to, answer question, because that would be in violation of their Fifth Amendment right, correct? So we could only do what we can do, but at the same time, the public does demand certain information to be, put out. But the public must also understand that there is certain, findings that cannot be put out in public because it will violate, the individual or the, whoever it is that is being in question will violate their rights. Because now we're going to put ourselves in a predicament. So as long as we do not violate their First Amendment right, and we do not, tell them that they cannot exercise their Fifth Amendment right, we should be okay. And then, of course, I think that, as a member as a whole, that we could all come into to an agreement as to what needs to be put out to the public. Because remember, the public demanded that we conduct this investigation, So they do have a right to know, but they must also understand that sometimes, just sometimes, you cannot divulge certain information because it will violate their constitutional rights. Thank you, sir.
Thank you, Rep. Odon. Rep. Flores.
Thank you, Chair. And I agree. I think the biggest thing here is that we are acting to conduct an investigation, right? And in any way, shape, or form, when you are conducting an investigation, we already know what is privy under OGA, and we already know what shouldn't be exposed to the public. What we don't want is to cause any more separation when we conduct this investigation by, saying our piece and our point of view because of this is how we feel. Now that's different when we're conducting ourselves in a manner in which this committee should uphold, which is to conduct it in a dignified, just, and fair way, as in any courts, if that's the case. But we're not the court. We're not the judiciary. We are House of Representatives, and we have the ability and the powers to conduct our own investigation. So I think in terms of what should be out there, we all know, and even the attorneys and our counsels will tell us, no, you can't do that. I think we all know that. We need to start changing, and at least if we're going to say something to the public, we must educate them in the manner in which we are conducting ourselves, which is to conduct their own due diligence if they want to, but in no way, shape, or form should we present ourselves and be like, well, this is how we feel, and I feel this, that we should be moving this way. If it's not the consensus of the entire committee, then why should one person move to the left and the rest of us move right? All I ask from this committee is that in a subsection there, anything that should be given to the media would come out from the chairman. That's it. Whether you want to impose a gag order or whatever, those are housekeeping rules that we should decide on as a committee. I think everyone's job here is to actually put a close to this and move forward. We all need to heal, but the only way we're going to do that is if we get this done. And I support everyone in this committee. However, I do still feel that there is, it's still sensitive. So thank you, Chairman. I yield. I leave it up to you to decide how you want to develop your rules. And I respect that. Thank you.
Thank you, Rep. Flores. Any last comment, Rep. Camacho?
Pues no, todo it naman gaitoris, no? Pues, is there anything in the rules that, allows us to recuse ourselves? Because I'd rather not.
We haven't crossed that road yet, but I'm sure there'll be some where we have to recuse. And we'll get there when we get there. I'll leave it to the council to write a generalized rule regards to that. Any further? With that, if there's no further questions from the rules and so forth, I would like to recognize now the vice chair.
Thank you, Chairman and colleagues. This time I'd like to motion to authorize the chairman on the Federal Assistance and Disaster-Related Funding Special Committee or his designee to issue 1301 to 1309 letters and subpoenas found under 1 CMC subsection, to issue 1301 to 1309 letters and subpoenas. So moved.
There has been a motion mentioned by the vice, and if in second, all those in favor say aye. All those opposed say nay. Motion carries. Moving along. Short recess. Thank you, members, and I would like to recognize again the chair, vice chair.
Thank you, Chairman. This time I'd like to motion to request Speaker. Oh, I apologize. I withdraw my earlier motion, my previous motion, and would like to make a new motion. I motion to request Speaker Villagomez to refer Communications 22-121 dated January 4th, 2022 to this committee and all pending bills related to this committee. So moved.
Has been a motion offered by the vice chair and has been second. All those in favor, say aye. All those opposed, say nay. The ayes. Short recess. Rip.
Cassetti?
Okay, the flare, the floor, the flare, the floor would. The chairman will recognize the vice chair.
Thank you, Chairman. I withdraw that earlier motion and put this into motion. I hope this motion goes. At this point, I motion to request that the chairman, Yumo of the Federal Assistance and Disaster Related Funding, receive House Communication 22-121 dated January 4th, 2022, and all relevant bills related to this committee. So moved.
Thank you, Chair, Vice Chair. There has been a motion offered by Rep. Probst. All those in favor or discussion? Ready? All those in favor say aye. All those opposed say nay. The ayes have it. Thank you, members. And before we close, is there one more? So I apologize, Rep. Probst.
Thank you, Chairman. This time thank you. At this time, I motion to authorize the Chairman of Federal Assistance and Disaster Related Funding or his designee to issue letters and subpoenas found under 1 CMC subsection 1301 to 1309. So moved.
There has been a motion entered by the chairman, vice chair. All those in favor? Say aye. All those opposed say nay. It's on. It's on. All those in favor say aye. All those opposed say nay. The ayes have it. Is there any more additional? We're good. That's it. Yes. Moving along. Item C. I believe the council has mentioned that in his previous when he was discussing the authority under the 1301 to 1309 supporting documents, and also by the motion of Rep. Or the Vice Chair requesting that all communications and related bills that are related to the federal assistance will be referred to this committee. So I believe that's all been addressed. Is there any other? If there's none, move to miscellaneous. Rep Flores.
Thank you, Chair. The next date of this meeting? For any updates, or can we calendar that?
We're not calendaring anything right now. As you've heard, we will request the speaker to send or refer the bill to this body. Then we can move forward with any other further. So there won't be any dates right now. That will be upon the issuance of the
Thank you,
communication.
Chair. Follow up then. So how long will it take for the chairman to request to file all of these things, to get all of this stuff done? How long would it take the chairman to,
The chair would, if
based on the motions that we have all
yeah,
voted on?
so I would issue a letter out today. If we don't, obviously, we're not going to make the 72 hours for the session. It will be a communication. If should we amend the rules tomorrow, then we'll have it then. Otherwise, we'll be on the next session. No, that's well, hopefully. Any other under miscellaneous? With that, this special committee will stand adjourned. Thank you.